Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, and this brings us to People v. Michael LaFave. It is two files, 24-6895 and 24-6992. Counsel, you want to state your appearances for the record, please?
Melissa Goodrich, Wayne County Prosecutor.
Good afternoon, man. Please, Court, Kareem Johnson, on behalf of Mr. Flay, who stands to my immediate right.
Okay, and good afternoon. We're here for sentencing in 6895 for possession methamphetamine, a 10-year maximum, 10 to 23 months guidelines range. 6992, a possession controlled substance, 2-year maximum, 7 to 23 months guideline range. Have you had a chance to review the pre-sentence report and recommendations with your client?
Yes, Your Honor, I have.
Any additions or corrections to the factual information in that report?
No, Your Honor.
Any challenges to the advisory guidelines scores?
No, Your Honor.
Ms. Goodrich, any additions, corrections, or guidelines challenges?
No, Your Honor.
Okay, I did receive and review a letter in support of Mr. LaFave submitted by Ms. Portman. So wanted counsel to be aware I did have opportunity to review that. Anything you want to say in your client's behalf?
Yes, Your Honor. Thank you. First, I'd like to thank the court for reading him over. I wanted the court to take a good look at Mr. LaFave. I think the court has practiced defense, and one of the more encouraging things about this job is when you meet a client that is suffering from addiction, and as you go through the process, you see the objective evidence that they have gotten all drugs and addiction out of the system. His face is cleared up. He's gained weight. He looks much better than he did when I first met him, and there was emotional suppressed in this case. I think the court saw him on video and saw his body, his mannerisms. I think he looks totally different. For the past, I think, 5 years, these last 10 months, the first time that my client has been free of all controlled substances, which would include methadone. The court has to sentence, my client on 2 matters. I think, and I understand what the jails and what jails try and do, but I think the contraband case just illuminates how much pressure an individual is under when they are receiving a controlled substance in the county jail. And he did give a statement to law enforcement about how he was pressured to share that. He should have never done it. He shouldn't have done it. And now that he is no longer receiving any type of medication, the court does not have to worry about him repeating that type of behavior. In the possession case, the court saw the video. The court is well aware of the facts. When Mr. LaFave left his house that day, he left his house with the intent of being what I believe a good, productive father. He was taking his daughter to a local lake. His daughter got cold. He didn't have everything he probably should have had in terms of a kitty bag with change of clothes, towels, and things of that nature, and got his daughter back in the car and was rushing to try and get home because she was cold and crumb. And the court saw and heard testimony as to what led to the traffic stop and how that led to an arrest. And the client has talked about that, and we talked about if he's not involved in drugs, then that does not happen. It does not happen. And his daughter having to see him, deal with the police and be arrested, and having to wait for the mother of his child to come get him. None of those things happen. That was a low point for him. That was an embarrassment for him, and he is ready to do better. He has been accepted into Mission Bible Training Center rehabilitation program, which is a 8 to 10 month inpatient program. We believe that he is on the cusp of finally being rid of the addiction demon. And he has joined in court today by several members of his family. His mother here, his stepdaughters here, his stepfather's here, neighbors here, mother of his child is here, and his grandma are all here. they have been paying his rent, although he has been incarcerated for which is almost a full calendar year now. If the court agrees with the defense sentence recommendation, they are willing to commit themselves to this court and make sure that he makes it to any probation check-ins and gets to the inpatient rehabilitation center, Mission Vitamin Training Center. The mother of his child is here in full support of him to continue co-parenting and helping to ensure that he stays on the right path. And I think that what the court has to do, obviously with somebody with a record like my client, is determine why should the court believe that this time will be different. And I think the answer to that question for Mr. LaFleur is the amount of time that he has been sober this time. And the fact that we're not asking the court to just release him back to society, we're asking the court to order that he complete this 8 to 10 month rehabilitation program for drugs and alcohol. And he has a vast support system that has invested themselves both with time and financially, keeping his rent paid to make sure that he stays on the correct path now. It's just, I understand the points, of prior record variables and things of that nature, but, in cases like this, it really, I think, piles up on an individual. But the court has to look at the fact that somebody has done something more than once, and it's not his first time being involved in the criminal justice system. I'd like to remind the court that he still is serving a sentence in another jurisdiction, and that sentence won't end for another month. I think that sentence ends November 8th. So he still has obligations to another community that he has to complete before this sentence will begin. Does the court have any questions of me?
No, sir.
Thank you.
All right, thank you, Mr. Johnson. Mr. LaFave, you don't have to make a statement today, but you're certainly allowed to. Is there anything you want to tell me or no?
Yes. I take full responsibility on my actions, and I know I'm here for my poor choices. I was clouded under the addiction I had. I'm so very grateful now to be clean. And I let a lot of people down in the last couple of years, my family, my children, and that shame and guilt just eats at me. But I got renewed strength, new health, just new mindset. All I want to do is just be a productive member of society and my family. And just asking for help. I know I don't probably deserve it, but it's all I can ask for. Just want to be able to just be better for everyone, including myself. That's it.
Well, thank you, Mr. LaFave. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. The defendant is 38 years old. It looks like his first encounter with the criminal justice system was at the young age of 11. He has 1 prior felony and 11 prior misdemeanors. It looks like there's still 1 misdemeanor case pending in North Dakota. He served 5 probationary terms. 2 have been unsuccessful as an adult, 5 jail sentences. He's listed as being employed with a 9th grade education. His guidelines are 10 to 23 and 7 to 23 months. I think the concern here is outlined in the PSI was the criminal activity accumulating a lot of cases in a short amount of time. I agree with the PSI recommendation of the 2 one-year jail sentences. Thank you.
Thank you, Mr. LaFave. If you please stand for the court sentence. We're here for sentencing back in the spring, and I didn't go along with a sentence agreement, and so you exercised your right to withdraw that plea and go forward, and that's fine. That there's no, I don't hold that against you in any way. And now we're back here, having entered a different plea and back here for sentencing now. There are some things that troubled me that the original sentencing that still trouble me. I mean, I don't agree with your attorney that you're just out there that day trying to be a good dad. Because, I mean, the last time you had already entered a plea, now you didn't to this charge, but you had previously entered a plea to driving while high with your daughter in the car. So, you know what good dads don't do? Drive high with their daughter in the car, not in a properly secured car seat. I'm not saying you're a bad dad all the time. You were a bad dad that day. You're driving high and your daughter's in the car, not even in the car seat, not secured in the car seat. Police pull you, well, somebody complains to the police about your driving, so they wave you over, find this situation and find you got meth in the car. And now, after we had the benefit of the full evidentiary hearing, I saw a video of that car and oh my goodness, there's like, some of that stuff could have been within reach of your daughter. That car was a dangerous place for your daughter that day for several reasons. There's all sorts of trash all over that car, including drugs and drug paraphernalia. And she's not even secured. She could reach around and find any of it. Plus, her dad is driving it and he's high. So then you're on bond. You posted a bond on July 17th of 2024. Less than 2 weeks later, you were charged with a felony in Otsego County. You posted bond the next day in that county. Then by October, we saw you were not complying with bond conditions, and so we revoked your bond. Less than a month later, you're in the jail concealing your prescribed methadone by keeping it in your mouth, spitting into a bottle, hiding under your mattress, and then sharing it with other inmates. So that's the possession of controlled substance charge in 6992. So the 6992, I interpret the statute for you having committed a felony while you're in a penal institution in 6895 for a sentence you later became liable to serve to be mandatory consecutive. Even if I'm wrong about interpreting the statute that way, I certainly have discretion to run a sentence consecutive when you commit a felony while a felony is pending. And here I think there would be reasonable grounds to exercise my discretion for consecutive sentencing because you committed not one, but 2 felonies while you're on bond for 6895. One of them even while you're in a jail. In February of this year, you were sentenced in Otsego County to a year in jail with your out date being November. You do have a prior record that's not great, 4 juvenile felonies, 1 adult felony, plus the Otsego felony that you committed while this case was pending. Your prior convictions include drug and alcohol priors. They include assaults. They include thefts. I mean, you're really kind of hitting a trifecta of all the different types of crimes you can commit. You know, you don't seem to have one that's your favorite. You steal, you fight, you drink and drive, or you use drugs. I don't know what crimes you don't like to commit. And you started when you were real young. You've got a history of violating probation in the past. You know, I get a letter from the mother of your young child saying, you know, she needs her daddy home. Well, that's true. And you know who else who needs her daddy? You got a daughter in North Dakota. You don't see her. Maybe one of the reasons is there's a warrant for your arrest in North Dakota because you got a criminal case pending out there that you won't go back and deal with. Man. And then you come here today and I'm supposed to believe you're just out there trying to be a good dad and trying to be a productive citizen. I would like to believe that. What objective data points do I have that would show me any of that is true? The objective data points I have are somebody that started committing felonies while he was a minor and is still doing it now. And it doesn't matter if he's on probation or in a jail, he'll keep committing felonies. And he'll place the child that's in his care at risk of harm. In file 6895, there's a crime victims assessment of $130, court costs of $350, a $225 OUIL reimbursement, $68 in state cost. And was that OUIL reimbursement part of the plea? Oh, it was part of, that was part of the plea. Okay. And the advisory guidelines in that case are 10 to 23 months. The middle of that is 16 and a half. You know, I think somewhere near the middle is appropriate given the history I just outlined. So I'm going to, in 6895, commit you to the Michigan Department of Corrections for not less than 16 months, nor more than 10 years, and give you credit for 134 days previously served. That is within the advisory guidelines range, and as I've outlined, I believe to be a proportionate sentence. In file 6992, there's $130 crime victims assessment, $68 in state cost. I'm not going to assess court costs in that file. I am going to sentence you in that case to the low end of those guidelines and commit you to the Michigan Department of Corrections for not less than 7 months, nor more than 2 years. I'm going to run that consecutive, as I've already outlined, to 6895, so you get credit for 0 days previously served in that file. Mr. Lefebvre, if you want to appeal your convictions or my sentences or both, you can do so by filing an application for leave to appeal to the Michigan Court of Appeals. If you want a lawyer appointed for you, I would do so. You'd have to make that request within 6 months. We're going to hand you your appeal rights in both files. Ask you to initial one copy for us. The other one is for you to fill out if you want to take an appeal. Good luck to you, sir.
Yes, Your Honor, thank you.
So I stay here.
Thank you, Mr. Chair. Thank you.